Welcome to Gas, the true story of a toxic train derailment. I'm Ron Scholl. Last time on Gas, we considered how A-rail might have contributed to the failed rail that caused the Alberton chemical spill, and how various stresses in combination with rail wear played a role. We now continue with Part 6, Chapters 19 through 21. Chapter 19, Theories. Epigraph. Plaintiffs, are there any derails that you are of the opinion that were simply an act of God? Chief Engineer Keller answered that with some, it was difficult to see what could have been done to prevent it. Ronald Dunn was the only rail expert retained through all plaintiff liability cases. Based in Virginia, the civil engineer had over 40 years' experience in the railroad industry and was an expert on railroad engineering and rail wear limits. His argument hinged on rail wear. Dunn held that excessive wear could lead to overstressed rail and then fatigue failure, regardless of inclusions, but in this case, excessive rail wear on the high rail in curve 155 resulted in both the running surface of the rail and the wheel-rail contact stresses moving closer in proximity to the inclusion present in the head of the A-rail, Dunn reported. Repetitive and concentrated dynamic wheel loads on the rail, which also overstressed in bending, thereby caused the initiation of the VSH, he said. Old, worn, dirty rail. Dunn believed the VSH existed for certainly well over a month based on his experience and the amount of time it would normally take a VSH to grow several feet. The Sperry test showed an anomaly 6 weeks before the derailment. In Mayo, metallurgy expert Roger Steele opined an entrapped slag inclusion deep within the head triggered the VSH and was not a danger without rail wear. Steele determined the VSH started 5/8 of an inch below the current running surface, or half as deep as in new rail. The amount of slag inclusions was high, even for A-rail, but without one large particle of slag, which he speculated as the size of the tip of a ballpoint pen, the VSH was unlikely to have formed, he said. Steele likewise believed the VSH grew in stages. When the Y-shaped crack finally reached the head on the field side, a 12-inch partial headpiece fell out. In Mayo, civil and structural engineer Michael Matthews conducted a stress analysis of the rail and determined that wear and superelevation contributed to the VSH. When Dunn, Steele, and Matthews met in 1999, Matthews brought them together, saying wear, stress, and inclusions all related to the VSH. Derailments weren't documented as caused by wear and stresses. Instead, a defect caused the derailment. Matthews believed that defects commonly blamed for derailments originated due to increased stresses. In effect, he gave a rationale for regulating wear limits to help prevent the initiation of defects such as a VSH. Magistrate Leif Erikson declared the plaintiff expert methodology scientifically reliable. When liability finally came to trial in the Austin case, attorney Ted Lyon retained Dunn, but unlike Steele, Lyon's metallurgic expert denied that slag was involved in forming the VSH. Edward Cox had degrees in metallurgical engineering and theoretical and applied mechanics. Cox claimed the VSH was caused by overload forces, with stresses increased through rail wear. Uniquely, Cox was the only retained expert on either side to not find deleterious inclusions in N33 and N39, sounding like the 1996 CF&I and TSL reports. Like Dunn and MRL's James Hornaday, he didn't believe the origin piece was N33, but was among the missing rail pieces. Cox believed that a major defect would never get through the mill's machine rolling process without the rail tearing apart. If it somehow did, the rail would fail very early in its service life. Cox said the crack grew slowly, probably to several feet prior to the catastrophic failure. The VSH would have been visible on the field side of the rail. Cox's testimony tried to undercut MRL's defense that the VSH was caused by something over which they had no control, a gross manufacturing defect. Lyon's other expert, Dunn, still held that slag inclusions helped trigger the VSH, a mixed message to to the Austin jury. In part, the plaintiff theory that the VSH was slowly progressive was based on normal expectations for VSH growth and behavior, expectations that inform, for example, the FRA's regulations for VSHs. Also, they pointed to the March 1, 1996 analog Sperry tape, which showed an anomaly at what became the point of derailment 6 weeks later. Emerel fashioned an evolving theory. CF&I had found no evidence of gross inclusions and thought the rail typical of the time, but they weren't given the later alleged origin piece N33. At TSL, Stephen Riley reported that N33's inclusions were insufficient in themselves to cause the VSH, and that wear and fatigue contributed to reduce load-bearing capacity. Emerel then retained metallurgist James Hornaday, the first expert to identify a void or closed pipe, later dubbed a non-bonded area, and significant inclusions in N33, but who believed N33 was not the origin piece, which he thought missing. Emerel dumped Hornaday after Schlepp and kept Jude Igwemizi, and then hired Riley after he left TSL. Only in June of 1998 did Emerel declare N33 the origin piece, when their experts and attorneys convened at Mid-States Lab in Broken Arrow, Oklahoma, and developed the opinion that the VSH began in the non-bonded area of N33, as opposed to other areas of inclusions. Now Riley concurred with the Emerel team that the non-bonded area was the specific origin point. Riley said in the statement Emerel attorneys prepared for him that he was no longer sure if wear was even a contributing factor. James Freeling, Gary Wolf, and Jude Igwemizi would present the expert rail testimony for Emerel's liability defense in Austin v. MRL. Mechanical engineer Freeling was the first Emerel expert to opine that a non-bonded area was the specific point of VSH origin, though he was not a metallurgist nor a rail expert and had never previously examined a VSH nor a rail. Freeling coined the term non-bonded area for MRL. What others called a closed pipe, he likened to a flattened hole that did not bond together. He believed the origin point of the VSH had been just above a slag inclusion encompassed in the non-bonded area in the upper web or fillet. He thought the vast majority of VSH growth from 1/2 inch to a full 12 feet occurred in one sudden event. Freeling agreed that shortly prior to the derailment, a 12-inch piece broke off on the field side of the head. Freeling found wear not to be a factor, though he'd never identified rail fractures from wear before. Based in Ontario, Nigerian-born Jude Igwemizi was a physical and rail engineer who called himself an expert on rail stresses and contracted to set rail wear limits for railroads and conduct failure analysis. Igwemizi felt it highly probable that the VSH was initiated by a dynamic overload from an out-of-round wheel of a prior train. He opined that fracture was sudden, splitting the railhead in two along its length for over 12 feet, from nothing to 12 feet in one load. The Alberton derailment was the first time Igwemizi had analyzed the cause of a VSH, and the first time he had identified a VSH developing from a so-called non-bonded area. Igwemizi echoed that there were no early warning indications of a VSH on this train. Igwemizi agreed that VSH fractures were dependent on stresses, but opined that wear had no effect in regard to the stresses on this non-bonded area because he claimed that wear did not substantially affect stresses in the web of a rail. The web received only a fraction of the bending stresses as the railhead did. His conclusions on wear hinged on the VSH originating in the web, not the head. Igwemizi admitted that VSHs and railheads usually originated in the head fillet area. Gary Wolf of Rail Sciences Incorporated of Georgia was hired by David Potter to determine a causal analysis of the derailment. Wolf concurred that the VSH resulted from inherent defects and inclusions in N33 and its non-bonded area that were all virtually undetectable. He agreed that from the initiation of the VSH to derailment took only 1 or 2 trains. Wolf said a slag inclusion lay benign for many years and began to fatigue as the age of the rail increased. Still, he opined the fatigue was not a result of wear. Wolf thought an initial foot-long piece of rail broke out after the locomotive went by. The crew felt a lurch, but didn't hear typical broken rail sounds, like gunshot banging, he said. A gunshot sound would be caused by the wheel hitting a rough spot at the brake. Ronald Dunn also thought the lurch meant a piece, unrecovered, had completely broken out, not just the head field side. MRL attorneys denied that a 6 to 12-inch piece had broken out, except that it happened during the derailment or after the engines passed on the last previous train. In a nutshell, MRL claimed rail wear had nothing to do with the derailment, and plaintiffs claimed rail wear had almost everything to do with the derailment. The wear on Curve 155 and the failed rail, wear beyond MRL's relay standards, was indisputable, as was the 28-year age of the rail and its cumulative tonnage. Both sides generally agreed the failed rail was dirty rail. They differed on whether or not it was a rail, though MRL's argument was the lack of a surviving brand on the failed rail. MRL did not account for the A-rail brand on the missing rail piece that had a VSH and which the FRA witnessed in Keller's office. The sides differed on where the VSH origin lay, important because wear was held to more effect stresses in the head than in the web. MRL claimed the VSH started in the upper web and that stresses associated with wear played no role. Plaintiffs argued the origin lay deep in the head or even in a missing fragment and that wear played a role regardless of the exact location. Notably, the stringers that define the full 12-foot VSH ran in the head. It was important to remember that the failed rail fragmented during the derailment, and without definitive proof of an origin fragment and the fact of missing pieces, discussion of the exact origin point was hypothetical. Rail wear was factual. Plaintiffs alleged the VSH propagated in stages, as VSHs were wont to do, and as the FRA recognized, and that MRL should have had warning and likely did, beginning with the Sperry readout anomaly. MRL claimed that Curve 155's unusual VSH broke either during the derailment or after the locomotive of the last previous train. Either way, they claimed no warning whatsoever. The fault lay in bad rail, and the defect had been unknown until the abrupt failure of the rail. The Alberton train derailment was not an act of God. Regardless, MRL held there was nothing they could have done to prevent it, despite making various changes in operations post-Alberton. A logical conclusion was that rail wear and rail fatigue played a significant role in the failure of the rail after 28 years of service. A further logical conclusion was that the failed rail was a rail, despite that evidence of a brand disappeared. It also seemed highly unlikely that a 12-foot VSH could form in one or two trains. It seemed highly unlikely that the VSH formed from a dynamic load that had never before impacted above a tiny defect that had laid dormant for 28 years, independent of rail wear. But what if none of these arguments and evidence, missing or not, even mattered? Chapter 20. Preemption. Jockeying for the most persuasive theory of why the rail failed, plaintiffs feared a derailment out of their control. Preemption. Federal law overrides state or common law regarding interstate commerce. This truth loomed on the horizon like a decrepit trestle, even as plaintiffs chugged along, investing time and resources, arguing MRL knew they had defective worn rail and was negligent not to have relayed earlier or issued a slow order on Curve 155. FRA listed defects that required remedial action included various fractures and damaged rail, but not worn rail, old rail, A rail, or rail with inclusions. In fact, the FRA rejected excessive wear as a defect, writing, FRA believes that insufficient data exists at this time which would indicate the parameters for this condition, rail wear, should be proposed as a minimum standard. FRA believes the remedial action tables and specifications better address the risks associated with rail failure. These risks are primarily dependent upon defect type and size and should not be dependent upon the manner or mechanism which reveals the existence of the defect. In other words, The FRA was concerned about the manifestation of a rail defect, not the underlying causes. This policy ignored expert and railroader agreement that rail wear alone could eventually lead to rail failure by sheer loss of load-bearing capacity. Plaintiffs also argued that rail wear allowed inherent defects such as slag inclusions to create vertical split heads. But the FRA considered rail wear as a mere mechanism that revealed a defect, as if the risk lay only in the express defect, not the enabling mechanism. While the FRA dictated minimum actions for VSHs, they left it up to railroads to set their own policy on relay standards and remedial action based on rail wear. A railroad could violate their own standards and not break the law. Legally, they could run rail to the web, both vertically and on the gauge face, as Augie Cantu had suggested. However, a key section of the Federal Railroad Safety Act regarding track inspections read, "A combination of track conditions, none of which individually amounts to a deviation from the requirements of this part, may require remedial action to provide for safe operations over that track." This ambiguous statement offered a thread of hope to plaintiffs. Overall conditions, not FRA-listed defects, controlled here. Maybe. Plaintiffs argued that worn-out A-rail, susceptible to vertical split heads visible only from the field side, constituted a combination of track conditions, warranting inspection by foot and reduced track speed. A high rail inspection did not allow observing the field side of rail, where a VSH, such as the Alberton one, might first break to the surface. Plaintiffs argued MRL was negligent in not conducting an inspection that would have detected the VSH. The Federal Railroad Safety Act offered express exemption, so if MRL was not in compliance with a regulation, it could be grounds for liability. But the FRA purposely left some areas not specifically regulated, such as methods of track inspection, which generally imposed a reasonable standard of care. MRL failed that care, plaintiffs argued. The Federal Railroad Safety Act also regulated a twice-weekly inspection. To be in compliance for checking for regulated defects, it said each inspection must be made on foot or by riding over the track at a vehicle speed that allows the person making the inspection to visually inspect the track structure for compliance with this part. The only specific restriction was 5 miles per hour when passing grade crossings. The range in options was striking. At a reasonable foot speed of 3 to 4 miles per hour, the inspector would be much closer to the track. Inspection by vehicle, even at foot speed, would not be comparable. Drivers rode several feet above the rail with their line of sight projected several feet ahead. The FRA deferred to the discretion of qualified inspectors as to adequate speed. The FRA's final rules found there were too many variables, such as track condition, type track, and weather, for rules to be more precise. The FRA passed on the issue, MRL argued. Plaintiffs countered that the lack of regulation didn't mean any speed was adequate, but it was loosely defined by the FRA as whatever speed it took to be in compliance with making adequate inspections to catch defects. So, what was a reasonable speed given all the circumstances? Estimates of effective high rail speeds span the map. A walking speed of 3 to 4 miles per hour covered 4 to 6 feet per second. Former roadmaster Roger Babcock said he conducted high rail inspections at 10 to 25 miles per hour, 15 to 37 feet per second. Plaintiffs claimed MRL generally conducted inspections at 25 to 35 miles per hour. Chief Engineer Richard Keller suggested 35 miles per hour as a maximum, 51 feet per second. But said at trial, MRL typically went 15 to 25 miles per hour. High rail cars had surpassed former motor cars for inspecting rail because they could go faster, but speed had also increased over the years as MRL crews decreased and territories increased, changes dictated by economics, not effective inspection. BN limited their inspections to 20 miles per hour. MRL had no such instruction. FRA's Lee Klaus, who had inspected MRL's track, said he was comfortable with the speed of 20 miles per hour on high rail inspections. In 1998, during deliberations on final rules, the FRA declined to incorporate a 15-mile-per-hour maximum. A distinction was often made between curves and tangents. For example, that a rail was not safe on curves, that rail wore faster on curves, and so on. No litigant asked what was the acceptable speed for inspection on curves versus tangent track. The FRA did limit full-time inspectors to 125 miles a day. Plaintiffs' charges of questionable inspection practices were backed up anecdotally by the 1995 FRA Safety Audit Report on track inspectors' complaints of too much territory to inspect and not enough time, resulting in inadequate inspections. Former MRL Assistant Roadmaster William Levengood recalled fatiguing shifts of over 12 hours that many times affected thorough track inspections. Worker fatigue aside, what speed was too fast to catch vertical split heads or even a small breakout? At a speed of 25 miles per hour, a 1-second distraction or lapse in concentration could result in about 37 feet of track missed, and a full second of concentration on one side of the track meant 37 feet on the other side whisked by unobserved. Plaintiffs provided a list of things inspectors had to watch for at 25 miles per hour while covering the span of 2,200 feet of rail, or 4,400 feet worth for both sides. In 1 minute, vertical split heads, horizontal split heads, base fractures, corrosion, transverse defects, bad welds, bad apples among 1,300 rail ties, 2,600 tie plates, 2,600 rail anchors, and 20,000 spikes, as well as check the ballast and track geometry for proper gauge. The driver's eyes were about 6 feet above the rail, looking beyond the end of the hood. This was speed scanning from on high, fallible human eyes, and mental focus. Plaintiffs argued MRL should have done more walking inspections on curves because a high rail wouldn't enable small but visible cracks to be found. The BN circular emphasized the importance of walking inspections. The roadmaster and track inspectors should walk as many miles of track as possible each week, it said. This is an important method by which certain defects can be detected. Curves require special attention. But walking inspections for MRL were once-a-year snapshots in time. The main inspection method was high rail, which speed was not specified by federal regulation. Preemption. Plaintiffs also argued that rail wear should have prompted a slow order, which MRL denied. But MRL's Maintenance of Way Standard Practice Circular No. 1 said, good judgment must be exercised in setting slow order limits to ensure complete control of a train throughout the length of the substandard condition. Protection will be maintained until the substandard condition is corrected and is safe for normal speed. This includes tie and rail replacements, it said. BN Circular specifically said that when rail was worn below the limits in the table, the curve is to be slow ordered until rail replaced. But, as with relay standards, MRL could always argue that what mattered was railroad practice, be it the practice of ignoring internal policy. However, under the eye of FRA post-Alberton, MRL did place slow orders on worn curves prior to relaying. Regardless of the written intent of MRL's operations, neither worn rail nor A rail required slow orders per the Federal Railroad Safety Act, MRL attorneys argued. FRA slow order rules only addressed listed defects. Preemption. In sum, MRL cited preemption in denying that they should have done something more or different or faster than required by federal law regarding slow orders, track inspections, remediation of defects, or relaying worn rail or A rail. If MRL was in compliance with federal regulations, there was no basis for negligence, and state law could not override. But how to interpret imprecise regulations? The plaintiffs argued preemption existed only if the regulations were precise, such as a 5-mile-per-hour speed for inspecting crossings. But MRL also cited the doctrine of negative preemption, that state law could not regulate something that the FRA rejected regulating, such as rail wear or inspection speed. Plaintiffs cried that MRL was trying to prevent a jury from hearing evidence of violations by seeking to have judges summarily order on preemption. The long-anticipated ruling on preemption came in January 2000 in the Mayo case. Both parties agreed that to the extent federal regulations addressed an issue, preemption applied. But Magistrate Erickson found that MRL's argument that preemption applied even in the absence of compliance was not well taken. The question then was whether MRL negligently failed to comply with regulations. Erickson ordered plaintiffs could contest whether MRL inspectors met inspection regulations and whether the 40-mile-per-hour allowable operating speed on curve 155 only applied absent a reportable defect or some local safety hazard which would require action such as reduced speed, he said. Erickson ruled that the vertical split head was a local safety hazard requiring action. However, because neither worn rail nor A-rail was identified by the FRA as a reportable defect, they could not be used as proof of a violation requiring a reduced operating speed, regardless of MRL's own operating rules. A VSH defect did require a slow order and remediation, so the burden on the plaintiffs was to prove MRL knew in advance about the VSH and failed to act. With rail wear and A-rail untouchable, a key hope for plaintiffs was arguing the regulatory clause that addressed a combination of track conditions, though none were individually violations, as triggering prompt remedial action. With high rail speed, the regulations mandated inspections that allowed compliance with regulations. Here, Erickson ruled against automatic preemption. Plaintiffs were allowed to show evidence to prove inadequacy and noncompliance as to the manner of inspections. Plaintiffs argued that MRL knew about the worn rail, the A-rail, the heavy traffic, and hazardous cargo, and this combination required more special inspections to comply with regulations. Judge Malloy adopted Erickson's order on preemption. In the Austin case, plaintiffs asked for a reconsideration regarding the frequency of track inspections. In a cue to the plaintiffs, Malloy said if the Sperry test, for example, revealed a surface flaw that might indicate something more serious, then MRL may well have a duty to further inspect at that point outside of the routine inspections established by law. Such evidence is not preempted, Malloy said. So if MRL had a red flag, such as an anomaly on a tape, or a reported rough spot, plaintiffs could argue MRL should have followed up. Despite these surviving options, the plaintiff liability case against MRL had been drastically narrowed. The major issue of worn rail per se had been eliminated, not by lack of any merit, but by federal government's omission of regulation. Once again, they passed. While MRL's Dan Watts claimed they were regulated by the Federal Railroad Administration and have met all their standards, critics had long claimed railroads resisted regulation and co-opted the regulators. Preemption seemed problematic when regulations failed to be specific. The Federal Railroad Safety Act regulations on rail wear and inspection speed seemed an example of the industry policing itself. As was often the case in the dynamic relationship between government, industry, and public safety, regulation was limited by the political strength of a given industry. Perhaps the Alberton story could speak for the adequacy of regulations regarding rail wear. Supposedly meant to protect the public, the Federal Railroad Safety Act also clearly protected the railroad industry. Chapter 21. Tort and Punishment. Some expert witnesses received huge sums, but skyrocketing costs were a calculated investment because punitive damages were usually not insured. In the Austin case, the plaintiff sought $2.5 million and another $20 million in punitive damages. Liability was the supreme battle. As documents on worn rail and A-rail surfaced, coupled with sympathy over the nightmare of the evacuation and victims' chronic injuries, plaintiffs' attorneys seemed confident of victory. But rulings on preemption dampened expectations. Could MRL be found not legally responsible? Spill victims asked. Under Montana law, there was no strict liability for a train derailment. Plaintiffs' only remaining recourse, short of a trial only on damages, was to prove negligence. That MRL's failure to properly maintain the track on curve 155 made them liable for injuries. Negligence was defined as the failure to use reasonable care by action or inaction, failure to act as an ordinary prudent person or entity would act under the circumstances. A jury finding of negligence would make MRL liable for the derailment and exposed to more compensation. In a civil case, the burden of proof was on the plaintiffs to prove guilt by the preponderance of evidence. They must convince the jury that the claim was probably more true than not. MRL, quote, vigorously denied being negligent. Notably, in ruling in MRL's favor on strict liability, Judge Malloy cited the reasonable care standard of negligence law, along with federal regulations, as being supposedly sufficient to serve the public safety concerns. But Malloy was disturbed by the apparent assurance. He wrote, "What is curious about MRL's argument here is its position in this case that any rail, regardless of age, letter design, wear, etc., can have within it inclusions which are undetectable but can lead to a vertical split head resulting in derailment. If so," Malloy concluded, then negligence under Montana law could not control. He was concerned that while MRL held that even with due care and regulatory compliance, accidents occurred, that blameless victims had no legal remedy if a jury found no negligence. In what would become a notable aside, Malloy wrote that until the Montana Supreme Court ruled on some of the case issues, I may consider a jury verdict form whereby the jury would assess damages even if they do not find negligence. I invite counsel to consider the efficacy of so doing to avoid a new trial in the event the jury were to otherwise find MRL not liable. Negligence alone did not warrant punitive damages. Finding for punitive damages required clear and convincing evidence of malice or fraud with no serious or substantial doubt, more than a preponderance of evidence, but less than beyond a reasonable doubt. Under Montana law, fraud was defined as a representation with knowledge of falsity or concealing fact with the purpose of depriving plaintiffs of legal rights or causing injury. For malice, a defendant is guilty of actual malice if the defendant had knowledge of facts or intentionally disregards facts that create a high probability of injury to the plaintiff, while deliberately acting with intentional disregard or indifference. In determining the amount of punitive damages, all circumstances were considered: injury, actual damages, and sending a message to deter future acts of misconduct. Monetary punishment. MRL didn't want a punitive damages case presented to the jury. In Schlepp, Malloy denied partial summary judgment for MRL, which potentially influenced the settlement. As male plaintiffs made allegations of spoliation and withholding documents and raised the specter of the Schlepp sanctions, MRL motioned again for partial summary judgment on the claim for punitive damages. Plaintiffs must show conscious wrongdoing, MRL argued. Plaintiffs had no prima facie case, just numerous allegations in areas preempted by federal law, no less. There was no clear and convincing evidence that MRL acted out of fraud or malice in not moving faster to replace rail that broke due to an undetectable defect, they argued. MRL attorneys concluded MRL operates a safe railroad and had measures in place to prevent derailments such as the one that occurred in Alberton. But MRL did not prevent something that did occur, not to mention similar derailments. In Mayo, plaintiffs argued MRL had a history of unsafe operations, corroborated by employees and the FRA. MRL was aware of the inherent dangers of A-rail in its curves, including curve 155, and that vertical split heads had developed in A-rail. They knew rail wear triggered vertical split heads and that curve 155 was worn out. Knowing these dangers, MRL continued to run trains hauling hazardous chemicals at track speed over the worn-out A-rail in curve 155, they said. The derailment was inevitable, and a profit motive was the driving force of MRL's malicious indifference. MRL engaged in a game of Russian roulette, with the gun pointing at the individuals who lived near and around curve 155, they said. Mayo plaintiffs also attacked MRL's defense credibility, citing withheld documents and the sanctions. The Keller rail, an A-rail with a vertical split head observed by the FRA, has never been made available to anyone by MRL, they said. Plaintiffs claimed MRL's hiding, losing, or destroying evidence also subjected it to punitive damages. In Mayo, Magistrate Erickson recommended that Judge Malloy deny MRL's motion for partial summary judgment in early January 2000. Disputed facts were still not resolved. Whether the vertical split head was detectable prior to the derailment, how and why the vertical split head developed, and whether the rail should have been relayed earlier. Plaintiffs had presented evidence that MRL knew that a rail was in curve 155, that the rail was worn below their limits, of similar derailments in other curves, that a vertical split head was more likely to develop an A rail, that freight tonnage was significantly higher, that MRL hauled hazardous materials regularly, and that an accidental discharge would be dangerous. Erickson wrote, "From this a jury may well find that MRL acted with intentional disregard of the high probability of injury should a derailment occur. Such a finding would support an award of punitive damages based on actual malice." Soon after Erickson's recommendation, Mayo and all plaintiff attorney William Rosbach's cases were settled. Malloy did not rule on the motion for partial summary judgment. Rosbach entered into a confidentiality agreement that was rumored to extend beyond the normal gag on the settlement amounts. Naturally, he could not comment because of obligation to his clients. To the surprise of Ted Lyon and his clients, Judge McLean in Missoula County District Court ruled in favor of MRL's motion for partial summary judgment on punitive damages in late August 2000. The burden of proof was now shifted to plaintiffs to establish a prima facie case of actual malice. But, McLean warned, whether the defects were detectable or whether the inspections were adequate were only negligence issues. McLean distilled the issue to the vertical split head. MRL had no knowledge of it and therefore had not disregarded it, and plaintiffs had not established that rail wear caused the vertical split head. Notably, McLean did not address the Federal Railroad Administration clause. A combination of track conditions may require remedial action to provide for safe operations over that track, in dismissing A rail and worn rail as not being reportable defects. McLean's ruling was not binding in federal court, and Judge Malloy still had to rule in the Austin case, which would become Attorney Lyon's test case. Federal Judge Malloy ruled in March 2001 that because sufficient facts remained in dispute, he would deny partial summary judgment on punitive damages, but reconsider the issue after plaintiffs had closed their case at trial in Austin. For the time being, punitive damages were still on the table. And so, by the 5th anniversary of the Alberton derailment, plaintiffs remained hopeful for the big prize. The Austin trial of April 2001 was the only case to put MRL on trial for liability for the 1996 Alberton train derailment and mixed chemical release. On the eve of the trial, Lucinda Hodges wondered if the past 5 years had been worth the effort. It had felt right to fight for answers, but now she feared nothing would come of it. Even Bob Martin's case had led to nothing. She would probably end up filing for bankruptcy. Hodges feared the plaintiffs were being led to slaughter, that there would be no justice. Next time on Gassed, the true story of a toxic train derailment. The only case to try MRL for liability over the Alberton derailment and chemical spill pits plaintiff Sam Austin versus MRL and Burlington Northern. At stake is also MRL's negligence and potential punitive damages. The outcome will likely affect all remaining lawsuits. Until then, this is Ron Scholl. Thanks for listening. This podcast is adapted from the book Gas, the true story of a toxic train derailment. Visit Amazon.com to see the 2-book series. To access support material in the book, such as maps, photos, illustrations, and video links, visit my Facebook page Gas, the true story, or watch my Gas playlist on my YouTube channel at RL Scholl.